Constitution is now home.
The Charter of Rights and Freedoms, adopted in April 1982, was part of the Constitution Act to bring the Constitution under Canadian control.
We now have a charter which defines the kind of country in which we wish to live.
The creation of the Charter led to tense debate across the country. At the time, premiers feared the Charter would reduce their powers. To address these concerns, a deal was struck with the majority of the provinces to include a notwithstanding clause to allow legislatures to override rights for a limited time period. This deal did not go far enough for Quebec. It refused to sign it. McGill University political science professor Christopher Manfredi.
Formally, the Quebec government didn't accept patriation. Formally, the Quebec government did not sign on to onto the Charter. That does not mean that the Charter hasn't been popular in Quebec. In fact, there is a lot of public opinion that shows that Quebecers as individuals support the Charter as much as other Canadians. Quebecers have been as willing to use the Charter to advance their understanding of their own rights as have other Canadians.
The Charter greatly affected the role and responsibilities of the courts. Charter expert and professor emeritus at Osgoode Hall Law School, Jamie Cameron.
I think it was probably quite intimidating to the judges, because here they had a complete document of rights dropped into their laps with very few clues about how it should be interpreted. But one of the things that emerges in the early years of Charter interpretation is a determination on the part of the court not to, if I could put it this way, drop the ball again, the way the ball had been dropped with the Federal Bill of Rights.
When the Charter was adopted, Bora Laskin, the first Jewish Chief Justice, presided over the Supreme Court. 2 years later, Laskin died in office and Brian Dickson was named Chief Justice. Dickson is credited for laying the groundwork for the court's approach to the Charter. Former law clerk at the Supreme Court and law professor Adam Dodek.
Under Chief Justice Brian Dickson, the Supreme Court of Canada immediately embraced the Charter, and that fundamentally altered the court's role because prior to the Charter, the court did have the power of judicial review. They could strike down legislation as inconsistent with the Constitution as it then was, but that was mostly about federalism, who has the power to enact legislation. Under the Charter, when the court declares that a law is unconstitutional, subject to the notwithstanding clause, that's the end of the story.
Former Chief Justice of the Supreme Court, Beverly McLaughlin, credits the court for its work interpreting the Charter.
I became a judge in 1981, just the year before the Charter was adopted. And so through my career, I was able to experience firsthand how the Charter affected work and how the principles which govern Charter jurisprudence were developed. And I think the first justices in the mid-'80s, I wasn't on the court at the time, I didn't come on the court till '89, but they did a great job, in my opinion, of laying out the broad parameters of how Charter interpretation would go forward.
If you think back to the period from 1984 to the turn of the century, I would say that it was, it has to have been one of the most exciting periods in the evolution of Canadian constitutional jurisprudence in all of time, because there were so many, there were some landmark decisions that sort of set the framework for Charter interpretation. So it was individual rights versus the reasonable limits in a free and democratic society. And the court had to figure out how to make that calculation and how to do so in a way that was jurisprudentially sound, but also legitimate, legitimate in the broader sense of being acceptable to the public and the political community.
I, Michael J. Moldaver.
Michael Moldaver served as a judge on the Supreme Court from 2011 until 2022.
The Supreme Court took on its newfound authority with enthusiasm. And before too long, individual litigants were finding that they were getting far more success in the Supreme Court of Canada getting legislation changed or having legislation enacted than they had been by lobbying Parliament or the legislatures. And before too long, this came to the attention of interest groups across Canada, and these interest groups decided to take a special interest in appeals going to the Supreme Court of Canada that involved issues that were pertinent to whatever cause it was that they were engaged in.
Over the years, the Supreme Court has decided a number of high-profile charter cases that have impacted rights for minorities, in particular for women. Carrie Frock is a law professor and an expert on women's constitutional rights.
Women's equality rights were really beefed up in the Charter versus the Canadian Bill of Rights. There is a horrible track record of the Supreme Court deciding women's cases under the Canadian Bill of Rights, very technical arguments so that women lost. So women had an influence on Section 15, which is the general equality provision.
And now today, the people have spoken.
The Charter has also been credited in helping to advance rights for Indigenous peoples, says Naomi Metallic. She teaches law at Dalhousie University and is from the Listigouche Mi'kmaq First Nation in Quebec.
Yes, I think the Charter is a good thing, but I also think that we shouldn't rush to necessarily impose the Charter on the exercise of Indigenous self-government, but yet there still has to be protection of fundamental rights in that sphere as well, but there are other mechanisms and ways to do that.
The Supreme Court's decisions on some charter cases have led some people to question them and view the court as an activist one. Political science professor Robert Schertzer.
I think the Charter is a double-edged sword, right, as they say. It's revolutionized, in some people's minds, our politics. It puts the court front and center. It gives us protections from what governments can do to us as citizens. But what it also does is takes power away from elected politicians and puts it in the hands of courts. Right? So now courts don't act, right? They only respond. So it's us as citizens that are contesting what governments are doing, and the court then makes a ruling. But in making those rulings, particularly on the Charter, it has definitely given more power to unelected officials who some people argue don't have a right to make those kinds of decisions about our lives.
Now, whether or not the court has gone too far in a particular area under the Charter, that, first of all, I think that that's a matter of subjective interpretation. People differ on that.
One area where criminal law experts and court watchers believe the Charter goes too far is when it involves criminal justice.
The Charter's legal rights, as they're called, were, I think it's fair to say, a pretty big game changer for the rights of criminal defendants, and were a key part of the court's docket in the early years after the Charter was enacted, and even to the present.
Before serving as a judge on the Supreme Court, Michael Moldaver was a prominent member of the criminal bar.
You can't just look at this section, give it one interpretation and walk away. They are constantly having cases come before them that raise issues that were not raised in other cases. And as a result, the court is required not just to interpret a provision once and say that's it. They have been constantly inundated with case after case after case as to what those simple, straightforward words actually mean. Now that's all fine and dandy, but what that has done is brought a complexity into the criminal law that is really quite mind-boggling.
I think the courts work very hard to decide these chartered cases in an apolitical way without agendas. No judge comes in with an agenda saying, I'm going to do this or that or the other thing, in my experience. They're simply trying to get to the right answer based on what the Charter says, how the Charter operates, and the submissions of counsel on the issue before them.
Throughout the 150-year history of the Supreme Court of Canada, there have been a number of landmark decisions, from freedom of the press, to same-sex marriage, to Indigenous rights.
The court, for the first time, recognized the existence of Aboriginal rights at common law, which was part of a catalyst that moved us towards having Section 35 enshrined in the Constitution.
And for women's rights.
You know, it's hard to really articulate the kind of sea change that Morgentaler represented in terms of recognizing abortion rights and reproductive rights for Canadians.
From charter cases to reference cases, these landmark decisions by the Supreme Court have helped shape Canada. That is to come on CPAC's Inside the Supreme Court of Canada, 150 years of the highest court in the land.